people can join us as I'm giving my my hot air spiel. But why don't we kick things off here? Good morning to everyone on this first day of winter. Pretty exciting. My name's Tommy Johnson. I'm with the Portland Regional Chamber of Commerce. Welcome to Eaton Peabody's Growth Basics for Business. This is our monthly breakfast seminar series, which provides a forum to gain useful do-it-yourself workplace solutions and insightful, actionable tips. Along with Eaton Peabody, I also must thank our virtual sponsor, Anania Bailey, for allowing us to bring this event series to you for the entire season. This is our final Growth Basics for the calendar 2021, but we'll be continuing with another can't miss event on Tuesday, January 11th. Johanna Major of KMA Human Resources Consulting will present International Communications, a Strategy for Employee Engagement. Registration information can be found on our website. Today's topic is Startup Success Legal Q&A with Eaton Peabody. It's being presented by Katie Porter, Hilary, Forsley, and Hannah Colpritt, each from Eaton Peabody. We're very fortunate to have them all with us today. Now, like all of the Chamber's virtual signature events, today's presentation is free and will be recorded and made available for free replay on the Chamber's website and YouTube pages. To keep up to date on all the Chamber news and events, please visit our website, portlandregion.com, check out our events page, and sign up for our weekly email newsletter while you're there. Now, before we get to today's presentation, I would like to remind you that if you have questions for our presenters, please type them in the Zoom chat, and I can relay them to our presenters at the conclusion of the event. At this point, I'd like to acknowledge our presenting sponsor of the entire Growth Basics for Business season, Eaton Peabody. For the past 3.5 years, Eaton Peabody has been the exclusive sponsor of this series, and they continue their support with us this season. I'm pleased to invite Marketing Manager Nate Levesque to say a few words. Nate?
Great, thank you, Tommy. I want to thank the Portland Chamber for doing such a great job of putting these together and providing new and engaging content month after month. I think I've attended every single one of these, and I always walk away with something new. So whether this is your first Growth Basics event or your 10th, I want to thank you for taking the time to join us today. I'm pleased to be joined by my Eaton Peabody colleagues, Hannah, Hilary, and Katie. For those of you that may not be familiar with our firm, we are a full-service Maine-based law firm with nearly 50 attorneys serving Maine clients from offices in Augusta, Bangor, Brunswick, Ellsworth, and Portland. We assist companies of all sizes in many different industries, so whether you're an established financial institution or a small business just taking your first steps, we can help with all of your legal needs. To learn more about the services that we provide and the industries that we serve, please visit our website, eatonpeabody.com. Also be sure to follow us on Facebook or LinkedIn to stay up to date on legal updates and future presentations. Thank you. Back to you, Tommy.
Thanks, Nate. Nate's a pro. I can see him hosting this series for me in a year or two's time. He is a pro. And when he's not doing this virtually, I'll tell you, someday after COVID ends, and I know he knows what I'm going to say, we're going to go back to doing this in person, hopefully. And Nate puts out the best breakfast spread in Portland. He's got the best coffee and treats that you're going to find. But enough of that. So I'm happy now to introduce our presenters. With us today, our senior counsel, Katherine Katie Porter. She represents private and public employers in all aspects of labor and employee matters. She routinely advises clients on federal, state, and local employment laws, including discrimination, sexual harassment, retaliation, accommodations, leaves, wage and hour, COVID-19 compliance, whistleblower, and misclassification issues. Also with us is business practice associate Hilary Forsley. Prior to joining Eaton Peabody, she earned her Juris Doctor from the University of Maine Law School in May of 2020. At graduation, Hilary was awarded with the SBA Distinguished Service Award and the Faculty Significant Achievement Award. Impressive. We also have business practice associate Johanna Colpritt. Hannah's areas of focus include business formation and structuring, mergers and acquisitions, angel venture capital financings, securities offerings, and general corporate work. And I think at this point, I'll say, take it away, Hilary.
Great, we'll just get the slides started here.
Can everyone see that?
Yeah, Nate, it looks good. We can see it fine.
Perfect.
Well, thank you all for joining us here today. We're going to get started with where you should get started when thinking about starting a business. So step one, we would recommend is starting with a business plan. So this will just give you a chance to kind of get your thoughts out there on the purpose of the business. What are your goals, both professionally, financially? who's going to be involved with you, whether it's friends or coworkers, colleagues, family members, and also thinking about how you're going to fund the business. So thinking about your financial projections, the feasibility, what financial resources are available to you, and estimating these startup costs. So what's it going to take to get started with this business? And also thinking about your timeline, when you want to get the business formed, when you want to actually start the operations. All of these thoughts really help us as attorneys get you started and help you meet your goals that you've outlined. There's some great templates available online, but really your business plan doesn't have to be anything fancy. It's just getting your initial thoughts out there.
And Maine is an incredibly exciting place to be right now as an entrepreneur and as a small and or growing business. There are several resources out there that are willing and able and excited to help entrepreneurs. So this is just a few of them, and I apologize I wasn't able to include all of them because we're fortunate to have many, but we also recommend using these sources. Attorneys can certainly get expensive pretty quick, and I always recommend to those who are at the beginning stages, go seek out these professionals. They have a lot to offer and in a much more affordable way in those early stages of forming your business.
So we'll next answer the question, is it time for an attorney? General answer, yes. So get started in hiring an attorney and also just a general team of professionals who can assist you before your problems arise. It's much easier than cleaning up messes down the road. We just outlined a few, a few situations here where you might decide to consult an attorney. So before selecting your business form, the entity type, which we'll go into next, consult an attorney before that, before you're offering any stock or ownership interest to anyone else, before you're committing to borrow money and taking a loan, and before you sign anything contractually binding, whether it's a lease, a supplier agreement, anything that you would want an attorney to review before you start committing yourself. And then we just noted here, how do you communicate effectively with your attorney? Just be sure to communicate your expectations and goals so we can help you meet those milestones along the way, and also keep us informed. Either connect us with your accountant or your financial planner, just so we can all help you strategize and again reach those goals that you're committing yourself to. So one of the first things we'll get started with is the type of entity that you want to form. So on the left, you'll see on the slide some of the questions you might ask yourself to help you reach the answer to this question. So how many owners, what type of owners or ownership structure would you like to have? What's your business purpose? And then what are your business priorities? We'll think about the tax considerations and the liability considerations, and then also where you're going to operate. So as you're thinking about these questions and reaching out to your attorney, we can help you kind of come to a conclusion about what entity structure might be the most beneficial for you. So on the right there, you'll see some of the entity structures: sole proprietor, partnership, LLC, the C Corp, and S Corp, which we'll go into in a little bit more detail next, but those are the general options when choosing the type of entity you'd like to form. So this chart here just gives a high-level summary of the comparison between the different types of entities. We'll talk about how to form it, both in terms of what's the easiest as to what involves a little more work with formation. We'll talk about the liability with each type of entity in terms of giving you more or less protection. We'll talk about the different types of taxation and why you might choose one entity over another for different tax purposes, as well as the financing options available to you. So sole proprietor first, the easiest to form, generally unincorporated, so it doesn't really require any formal documentation or filings with the Maine Secretary of State. This is a singular entity type, so it's just one person and really no distinction between the individual and the company. So with this, that means there's no separation between business assets and liabilities, and then your personal assets and liabilities as a sole proprietor. So as the sole proprietor, you'd be personally liable for the debts and the obligations of the company. In terms of taxation, all business income and losses are reported on the individual's tax return. So the company itself is not taxed as a separate entity. And then in terms of financing options available to a sole proprietor, it's pretty limited compared to some of the other entity structures we'll go through. So going a little quickly through sole proprietor and partnership, as they're not as common, most of the entities we're forming now are LLCs or C corporations. Moving next to the partnership, this is generally governed by a partnership agreement, which is the document that kind of details the business relationship between the partners. However, a partnership agreement is not required. So it's generally just involving two people carrying out a business for profit. Because of this, it can actually be very easy to accidentally form a partnership through conduct, because there are no filings required for a partner to form a partnership. So just be careful of the conduct and the language between you and a potential business partner in order to avoid forming a partnership if that's not your intent. In terms of liability for partnerships, this will kind of depend on the different types. So we have general partnerships, limited partnerships, limited liability partnerships, all of which have different management as well as liability options for the partners in those structures. So moving next to LLCs, limited liability companies. This is pretty common for most of our small businesses now. It's kind of a combination between a partnership and a corporation, as you can see by this chart and kind of the high level summary of the two. So in Maine, this will involve filing documents with the Maine Secretary of State. We have the certificate of formation and the filing fees that are involved in that. We'll also draft a limited liability company agreement, which is generally very customizable and will outline the terms of how the members or the managers, the owners of the LLC, will govern the business operations and the management of the company. So generally the owners of LLCs are called members. There's no restrictions on the type of owners. It can be a single member or a multi-member LLC. You can also have manager managed limited liability companies where the managers are delegated the authority to manage the day-to-day business activities. Generally, members of an LLC are not personally liable for the debts or the obligations of the LLC. So you can see here in the liability company gives you better protection than the sole proprietor and partnerships, as we just discussed. As for taxation of an LLC, it is up to the members themselves. You can be taxed as a partnership or a C corporation, depending on what the structure is and what the goals are there. So again, this LLC is definitely one of the more common entity structures that we're seeing now. It's very customizable and has a little bit less formal restrictions than the C corporation, which we'll go into next. So pretty similar formation with LLCs and C corporations. We'll file the articles of incorporation with the Maine Secretary of State and the filing fees that go with that. We'll also draft bylaws and possibly a shareholders agreement as well that govern the management as well as kind of the ownership of the business. For liability, there's very limited liability for the owners. So you can see here, it'll give you the most protection. Taxation is a double taxation structure for C corporations, meaning that the corporation itself pays income, and then the shareholders will also pay tax on the dividends that are distributed there. In terms of financing, a lot more options available there. And here we have the owners as a separate entity from the corporation. So the corporation itself, you can kind of think of as having its own life separate from the owners, generally governed by a board of directors unless otherwise specified. And then those directors will elect officers to kind of manage the day-to-day of the business. You might have also heard of an S corporation, which you'll see is not listed on this entity chart here. That's because it's not actually a separate entity structure, but it's actually just a separate tax election status. So this is a status available to certain corporations that have certain shareholders and meet certain thresholds, which allows allows certain C corps to avoid double taxation. But again, it is subject to certain ownership restrictions. So that is a very high level entity comparison. There's a lot more to it. And again, this is something that you'll want to reach out to your attorney to before forming your entity, just so we can really walk through all of these different factors with you. And it is so fact specific depending on your specific business plan.
All right, thanks, Hilary. So now that you've met with your attorney, you've figured out what entity structure you're going to go with, whether that's an LLC or a corporation or one of the other options. How are you going to fund the business, right? Where's the money coming from? So I like to look at this as two primary sources of funding. The first being debt financing. So debt financing is probably what most of you typically think of when you think of funding your business. And that's typically involving loans, whether that be through a bank or whether that be through family or friends. There are, of course, advantages and disadvantages to debt financing. So as I'm sure many of you are familiar with, in terms of advantages, you're not giving up any control of your business. So you just have a promise to pay someone else, again, depending on who that may be, the bank or a friend or a personal connection. You're not giving up any control whatsoever. You're not giving up any ownership. It's simply a promise to pay back a certain amount of funds and on certain terms. So there may be interest involved. It may be for a certain period of years. You may be able to extend the term. That is all negotiable depending on who you are working with. In terms of disadvantages, of course, you have to repay the funds at some point. And so although the business may be going exceptionally well at the beginning, something, a pandemic might hit and things take a turn. And that obligation to repay your lender does not go away. Also, depending on the type of entity structure that you go with. So for instance, in particular, if you are a sole proprietor or if you're a single member LLC that's just starting out, you may be obligated to also provide a personal guarantee, which at that point you need to do a cost risk analysis. And then in addition, again, depending on who you're working with, who your lender is, the terms may be subject to change over the course of time. So again, I strongly encourage you to work with your attorney on, reviewing any loan documents, deciding what's best for your business at a given point in time. And the second option, big category of financing, is equity financing. And so this might be a little bit different than most of you think of when you think of financing. This is offering a piece of your business, essentially, so a part ownership, in exchange for a number of things. It might be in exchange for cash. It might be in exchange for oversight or advice or connections someone may have to certain industries or other professionals that you need the assistance from. So equity financing is typically more complicated than debt financing. That's a general statement. But when attorneys get involved and you start having investors come in, there are a multitude, as you can imagine, of agreements that come into place. So it'll typically start with a meeting, some negotiations. Someone will put together a term sheet. And then from there, you'll have several agreements. This may include a stock purchase agreement. It may include investors' rights agreement, a voting agreement, a right of first refusal agreement. I can keep going on. There are many. But of course, there are advantages and disadvantages to this approach as well. So typically with equity financing, we're talking about larger amounts of funds. So people are putting in quite a bit of money into your business because they believe in it and they believe that it's going to scale or grow or whatever the goal is at the end, maybe an acquisition or an IPO, for instance. They're putting in quite a bit of investment. And second is the flexibility. So you may be working with angel investors, you may be working with venture capitalists, depending on who it is you're working with. they have just become your partner essentially in the business. And so they may be more flexible to the terms and depending on how the business is going at that time. And then finally, as I alluded to at the beginning, typically these investors, they have influence, they have connections, they have experience. This may not be their first time, their first go around with a startup or an emerging company. And so with that comes a lot of really, really valuable insight, and they can typically help take your business to that next level. Alternatively, there are disadvantages. You are giving up, a piece of the pie, for instance, that may be small, it may be big. It totally depends on the terms that you've negotiated. This also, equity financing isn't necessarily available to every type of business out there. Typically, it is reserved to businesses that have the opportunity and the capability to scale very quickly. So we often see this with technology companies, just because of the way that their business is structured. And then as I was laying out a string of agreements that attorneys typically document and draft, you can imagine this gets relatively costly and time consuming. So depending on how urgent the funds are that you need, that may be a con to this approach. And now I'm going to pivot here, and we're going to take a look at the basics of intellectual property. So companies basically have three primary types of property. They have real property, which is your building, your parking lots, your infrastructure. You have your personal property, which are the computers inside, the desks, the furniture, things along those lines. And then you have your intellectual property. And intellectual property can be difficult to get a grasp of sometimes, because often intellectual property isn't something that you can touch and feel and necessarily see. However, as the world is growing, technology is expanding, intellectual property is becoming increasingly important, particularly to early stage companies if you capitalize on that intellectual property accordingly. So there are four main types of intellectual property that I'll just touch upon. There are trademarks, there are copyrights, there's patents, and there are trade secrets. And the first is trademarks. And so trademarks is essentially your brand. So it may be a logo, it may be a phrase, it could be a color, it could be a design, it could be a number of things. And this is typically how you distinguish your business or your company from others. And trademark rights are acquired by simply using that mark in commerce. However, we certainly recommend state and federal registration as well. Registering your trademark, it provides the exclusive right to use your trademark nationwide. And it also allows you, many of you may be familiar with, for copyright, we've all seen the small c with the circle around it over whatever the item is that's copyrighted. Similar, you can use as a little R and it goes next to your trademark. And so that typically, it discourages others from infringing upon your mark. So I like to use some examples when you're thinking of trademarks. It usually helps kind of paint a picture. So some examples of names that are trademarks are Calvin Klein. When you hear that, you think a certain clothing brand, or when you hear George Foreman, you think of a grill. You can also, like I said, you can have brands that are trademarked. So for instance, Coke for soft drinks, or Apple computers. The Apple and the Coke would be your trademark. You can also have designs and slogans. So for instance, probably one of the most classic and well-known is the Nike swoosh. That would be Nike's trademark. Similarly, McDonald's, the yellow golden M, that's also a trademark. And then finally, you can have phrases or slogans trademarked that perhaps you've used in commercials or using on your advertising or on the packaging. So for instance, America runs on Dunkin' would be a good example for Dunkin' Donuts. And similarly is Taste the Rainbow for Skittles. And then the one other very important thing that I want to talk about with trademarks is this sliding scale. So your trademark could be descriptive on one end, or it could be distinctive on the other end. And as just first and foremost, you want your trademark to be distinctive. You do not want it to be descriptive. So on the slide here, you can see that their log cabin homes is a very descriptive phrase for or mark for describing what it is that you sell. You probably sell log cabin homes, and you can't trademark something that is purely descriptive of what it is that your good or your service is. Alternatively, if you look at, for instance, on the other side of the scale is arbitrary marks. Those are words that have a meaning already. They're already a dictionary term. However, they have nothing to do with what you're using the mark for. So for instance, apple, if you were to look that up in the dictionary, you would see a certain type of fruit. However, many of us, when we hear the term Apple now, we think of iPhones and computers and iPads. So you can get trademark rights when you're using a word arbitrarily. And then even better than an arbitrary mark is a fanciful mark. And that's an example of a word that did not exist before you started using it with your business. So for instance, Kodak and Nike, those don't have any other meaning other than the association with that particular brand or company. So the next one I want to talk about is patents. And patents are a right that the US grants to a particular inventor for an invention that he or she has created. And basically a patent right, it allows you to make, use, sell, offer into commerce this particular invention in the US. And it prevents others from doing that. And it prevents others from importing that particular invention into the US. So you essentially have a monopoly on that particular item or service or whatever your invention is for a certain period of time. Typically, it depends on what type of patent you have. You could have a design patent, you could have a utility patent. Depending on that, I've seen somewhere between 15, 20 years typically is the protection that you're offered. And of course, you can't just get any invention patented. It needs to be useful, it needs to be novel, and it needs to be non-obvious. And what I mean by useful is that it needs to have a specific purpose to it. It can't just apply freely as a good idea. It needs to be novel in that it needs to be original and not necessarily known by several other individuals before you. And by non-obvious, I mean that it can't be a take on an already existing invention, that you have simply taken a very obvious substitution, perhaps it's an ingredient or a little tweak in the mechanics of, to create what you're claiming to be a new invention. It needs to be something that cannot obviously be a substitution for an already existing invention. And so dates are really, really critical with patents. So the first to file for patent rights receives the rights. And once that you have publicly disclosed your patent in commerce or in the US, you have 1 year to file for registration of that patent. So this is what I believe Hilary had alluded to this in her beginning of the presentation, is that it's really important to go seek an attorney early on, even if you don't think that your business is, a huge corporation by any means. You may have some really, really valuable intellectual property that you want to make sure you're hitting all the specific dates to make sure that you get the rights that you deserve for that. The next type of intellectual property I touched upon are copyrights. And many of us are probably relatively familiar with copyright. So that's typically for original works of authorship. And those works of authorship can come in different forms. They could be over on the side here, you'll see they could be a literary work. That's what most of us probably think of. That's books and periodicals and manuscripts. It could be dramatic works, and that's screenplays, for instance. It could be graphical or sculptural works. So any kind of art reproductions, photographs, prints, maps. Technical drawings, things like that. And with copyrights, typically the right that you get is for the life of the author and it lasts for a period of 7 years thereafter, after the author's life. And copyrights are similar to trademarks in that you don't necessarily have to file for registration to have that right. Typically, once the original authorship is created, you automatically have rights. However, again, we recommend that you register your copyright. That puts others on notice of it. It allows you to use, the little C in the top of the circle. It'll deter others from infringing upon your copyright, recreating it, plagiarizing. And really, really importantly too, is that registering your copyright, if someone does infringe upon it, then it gives you the rights to bring an infringement claim and also to seek certain awards that you wouldn't otherwise be able to seek in court. So certain attorney's fees and other damages. And the last type of intellectual property I will touch upon are trade secrets. And trade secrets are unique from the first three that I just discussed in that you actually don't register trade secrets. So I'll back up a second and describe. So a trade secret is any kind of information that has some type of economic value. Typically, you're going to have another form of value. And it's the reason that it has that value is because others don't have access to that information. So it may be a recipe, or it may be a certain, coding, software, things along those lines. And the third essentially factor that makes up a trade secret is the fact that the company or the individual, whoever has that trade secret, has reasonable efforts and mechanisms in place to ensure the secrecy of that trade secret. So examples of trade secrets may be the formula for Coca-Cola, or the coding for Adobe's Photoshop program. Things like that. And you don't register your trade secret, you just simply keep it a secret. And so working with an attorney, again, they can often provide some really valuable insight and tips and tricks to how to keep it secret. It may be a matter of just making sure you're keeping up to date with changing your passwords. It could be that only certain individuals have access to certain rooms or locations in the office. Only certain people, you may have confidentiality or non-disclosure agreements put into place that employees have to sign who have access to this secret information. So again, work with your attorney, protect your intellectual property. Those assets are incredibly valuable. And we want to make sure that we help you protect those.
So we'll wrap up this first section just by touching on some data privacy and cybersecurity issues and ways that attorneys can help small businesses with those. Generally, first step is having a plan, both a plan to protect your data, but also a response plan in the event that you have a data breach or cybersecurity incident. Planning ahead so you as a small business know who to contact in the event of one of these incidents, whether it's law enforcement, your insurance, your IT team, your attorney, a regulator, customers. It's all going to depend on the type of incident that occurs. Also a plan just for preventing the disclosure of data and preventing data breaches itself. So limiting who can access personally identifiable information, creating strong passwords, backing up data, and then also establishing training and policies for employees in order to train them on the best security practices, as well as reporting incidents, especially in a time where so many individuals are working from home as well. So you'll really want to touch upon these things with your employees when your business gets to the point that you have employees. We'll also mention insurance. So general liability insurance sometimes covers basic cyber liability. However, certain industries actually are required to have additional cybersecurity insurance, and it might also be an option or something to consider even if it's not required for your industry. And then lastly, on this piece, we'll just mention that small businesses, especially here in Maine, are not immune to cybersecurity incidents or data privacy breaches. We've certainly seen examples here in Maine, unfortunately. So just having a plan in place as to how to protect this information, train employees, and then having an incident response is certainly something that an attorney can help with, and it's very beneficial even to small businesses here in Maine.
Well, thank you very much. So I am an employment lawyer here at Eaton Peabody and work with Hilary and Hannah on a bunch of our clients who are startups and emerging businesses. And so what we're going to talk about today in this second half of the presentation is Hiring Workers 101. And this is relevant not only to startups, which we're dealing with this morning, but also to all clients I work with. It could be an established business that's been operating for many years. Whenever you hire an employee, you always want to think about these issues, talking about classification of workers, documenting the relationship with those workers. Do you have an HR function? Do you really need it? That's a critical question when you're starting a business, because of course that's more overhead, but it will, yield dividends at the end of the day. Notices, posters, employee handbooks, what do you need, what's necessary, and what's sort of a good thing to have, but maybe something that you don't want to include at the beginning of your business when you're starting your operations. Teleworking, this is very relevant to all of us now in this new world of COVID. So we'll talk about the advantages and concerns of teleworking. And then I'll touch briefly on employee benefits because those are critical to attracting new talent these days. So next slide. All right, first thing, classification of workers. So when I work with clients, I always ask initially, especially with startups and emerging companies, who are you working with? Tell me a little bit about them. And that's because I want to understand what the relationship between the parties is so we can assess if there's any misclassification. With misclassification, there's a lot of liability, and even beyond liability, classifying workers properly, having a workplace where things are harmonious is critical to culture, which is a big deal for every business. So the initial question is going to be, do you classify your workers as employees or do you classify them as independent contractors? Now, here in Maine, we actually have a statute which sets forth, very specific criteria to meet the standard or to be classified properly as an independent contractor. And we've set forth the statute right here. So you'll see in section A, each of those criteria 1 through 5 has to be met. And you'll see in number 1, the person has to have the essential right to control the means and progress of the work, except as to final results. So really, that's sort of getting at the main question of the analysis of whether someone should be classified as an employee or a contractor. And that is how much control the business exercises over them. So you've got 1 through 5 in section A, and in B, you have to meet at least 3 of the following criteria. So just to sort of step back from the statute itself, which of course, when you are classifying someone as a contractor, we'd advise talking to an attorney to make sure you're doing it properly and that you've met the criteria in the statute. That's if you're operating in Maine. But, the question is control. So with an employee, generally the business is saying, when, where, what they're doing, they're controlling hours, they're making sure that person's subject to policies, employment policies in the workplace, adhering to those policies. A great deal of control is exercised over those individuals. When you have an independent contractor, generally the work is project-based. Probably they specialize in a specific type of work. They may actually operate or contract with you through their own LLC or business structure that Hilary and Hannah laid out for everyone. So they also will oftentimes work with other clients and be highly skilled, as I said, in an area. So again, very specific inquiry, great to deal with an attorney and head check that you are classifying the person properly. So in addition to whether or not someone's classified properly as a independent contractor or an employee, you want to, if you've determined that they should be classified as an employee, the next step in the inquiry is, Are they non-exempt or are they exempt? And so a non-exempt employee is sort of the default in my mind and generally in the employment practice. So a non-exempt employee is someone who will pay at least the minimum wage, and you will pay them overtime. So that's time and a half in Maine for all hours worked in excess of 40 hours in a work week. I should note that, we do have clients that work in a variety of jurisdictions. So they may have Maine employees, but also some employees in California or Colorado. And I should just note that overtime can be calculated differently in different states. So if you are a business starting out, obviously we're operating in the age of COVID, so you may have some employees in California. You want to track their unemployment according to California law, which is a little bit different. Just something to note. So with non-exempt employees, obviously you want to make sure they're paid the minimum wage. You also have them, be paid overtime, but you also want to have them track their hours so that you make sure that, when they are working overtime and when that overtime payment needs to kick in. It's also important to have them track their hours, because if you had a dispute down the road and they said they worked, a lot of overtime and you didn't have hours, timesheets to show what they actually worked, then you might have an issue about, a wage claim. And so having employees track their hours at the outset is a great way to start the relationship. So exempt employees, that's when an employee falls into one of the exemptions or exceptions to the overtime rule. And that's going to be for folks who are executives, professionals. There's also an administrative exemption. That's not exhaustive of the exemptions to the overtime rule, but those are some of the common exemptions that we deal with. So to be an exempt employee, you need to meet two sort of high-level tests, and that's going to be that you make the salary basis, which is going to be the higher of federal or state salary basis, and that's going to be about just over 35,000 federally. And as of January 1st, 2022 here in Maine, just over $38,000. So in Maine, it'll be the higher of the two and the Maine salary basis. So first step of the analysis, does the employee make the salary basis? Great, let's say they do. So we're going to go into the second inquiry, which is whether or not they meet the duties requirements. You're not going to look to the job title. So let's say someone's classified as an office manager. That's not on its own going to sort of do away with the analysis. You need to actually ask, what are their duties? And for an office manager, for example, or administrative assistant, they're going to probably fall into the administrative exemption. So the duties question there is, do they exercise independent discretion and judgment over matters of significance for the business? So, that is a fact-specific inquiry. I've had a lot of, issues in the past with administrative assistants potentially misclassified. So always good to check in with an attorney that you've made the right call when classifying employees as either non-exempt or deciding that they should fall into one of the exemptions to the non-exempt overtime rules. So that's the question about exempt versus non-exempt. This is when you've looked at, whether or not someone should be an employee or a contractor, and you've decided they're going to be an employee. The next question is interns. How should we treat them? Many of us have had in the past an unpaid internship. I certainly have, but that's really not, that's not the standard these days, / it's not really what we should be doing. Oftentimes, if an intern is working, they're grabbing coffee, the classic example, they're making copies, they're writing up a report for you, that should be work they're paid for at least the minimum wage. So there are some exceptions to that, which generally is if someone's purely a trainee, they are getting educational credit, they are just supervising the work you do, observing, maybe writing a report for a class, for example. That's a different situation. That's when they may, it may not be that they're required to be paid, but again, please consult with an attorney because those are sort of the exception, not the rule. So, why are we so concerned about classification? contractor, employee, non-exempt, exempt, and then getting the intern payment correct. That's because liability for misclassification or failure to pay an intern is significant. For example, you could have tax liability. You should have, if an independent contractor was misclassified, there can be situations where you'll have a claim that you should have been withholding taxes from payments to that individual. There's potential wage liability. So if a contractor argues that they were misclassified and they were paid less than they should have been paid if they were actually properly classified as an employee, a non-exempt employee, because they worked all of this overtime during the period of the contract, that can be an issue for you. You could also have an intern argue that they should have been paid. They were not a trainee. And so you paid them less than minimum wage and they worked a lot. So they should have been paid overtime. All of this can create like pretty enormous liability for companies, depending on the circumstances, especially because under Maine law and many other jurisdictions, laws, for unpaid wage claims, employers can be liable for treble damages and the other party's attorney's fees. So the cost can stack up pretty quickly. And another risk and liability associated with misclassification is, benefits, liability with respect to benefits. So a contractor could say, well, I should have been an employee, I was misclassified. And, because I should have been an employee and I worked with them for such a long period of time, I should have been offered benefits and I was not. And for example, I had a catastrophic, health event and, the employer should be on the hook for that. I've actually dealt with that sort of claim in the past. And so, it's a real story and there's real liability attached to that. And so in addition to monetary liability, there's also just the headache for new businesses and established businesses of dealing with investigations by governmental agencies. You'll have to get attorneys involved. Of course, there's legal fees associated with that. So getting the classification of workers right from the outset is critical. And in addition to all of the liability we just discussed, if you're a new business, you're a startup, you're probably going to be raising funding and rounds of funding. So Series A, Series B. And as you do that, there'll be diligence into each deal. And so I usually get involved to, if I'm representing the client, to pull all the startup that's having the seed funding, I'll, pull together all the diligence. And a lot of investors are looking into employment issues these days because of the liability I just discussed. So getting it right from the outset makes those transactions, less expensive for you as an emerging business, and also just a cleaner, easier, less headaches transaction. So documenting the relationship. So we've done our classification analysis. You've consulted with counsel. You've got it all buttoned up. Now, the next question is, do we document it? I think it's critical to do that. And that's because, documenting the relationship will sort of protect you if there's claims down the road and, also create understanding with everyone. You're on the same page with your employees and contractors about payment, timing of payment, and any restrictions that they're under associated with your working relationship. So the first thing I'll start out with talking about is choice of law, actually. So in COVID, the question is, a lot of people are working all over the country, or maybe they're working in the office, but you want to think about where they're working, because if you don't have an agreement that locks down the law that'll apply to this employee, then the law of the state where they're working may control the relationship. So for example, if you have a Maine-based startup, but you have an employee who's working in California because it's COVID and it's fine, then California law may apply to that person and may actually invalidate some of the restrictions you put on them, which we'll get to in just a moment. So fixing the choice of law in an agreement is very important. So let's go to employment agreements. Do you want a term or an at-will employment agreement? Generally, term agreements that's an agreement where the company is agreeing to employ the employee for a specific period of time, and they can only be terminated, subject to certain termination provisions. For example, if they engage in cause or bad behavior, which you define in the agreement, those generally are reserved for executives or, highly sought after special employees that you really want to lock in. So that's not your sort of default agreement, but something to keep in mind if you do want to recruit, an executive, they may expect a term agreement. Definitely something to have an employment attorney help you draft. An at-will employment agreement is sort of the default here. That means that you're setting out the terms and conditions of employment in an agreement, but you're both acknowledging that either party may terminate the agreement at any time for no reason without notice, unless you put a notice provision in the agreement. Let's just assume that we're going to be drafting an at-will employment agreement. You want to set forth pay. So are they paid hourly? Are they paid salary? If they're paid hourly, usually they're going to be non-exempt. You want to make sure that they understand they need to track their hours and set forth sort of the structure for that. You want to advise them if they'll be eligible for any bonuses. If there are bonuses they're eligible for, you want to set forth the conditions on those bonuses. For example, if it's discretionary bonus or it's a fixed bonus at the end of the year, they need to be employed in good standing on the date that such bonus is paid, or it will be forfeited. That sort of thing is important to be very specific about in an agreement, so there's no misunderstanding down the road. Also, you want to be specific about benefits. Are they, eligible for benefits? Will they be in the future if they're not at the time they start? That's all very good to put in an employment agreement with an employee. Restrictive covenants. This is the most important thing from my perspective for emerging businesses and established businesses. You want to make sure that whoever you have signing on is going to have access to your confidential information, your intellectual property, as Hannah discussed. You want them to be, signed up with certain restrictions so that, while they work for you and they are absorbing all that information, should they leave, there are some restrictions on their ability to use that information. So what I generally look for and include in employment agreements are confidentiality restrictions. You probably will need to include some carve-outs. So definitely work with an attorney on that. Intellectual property provisions, protecting the secret sauce, your trademarks, your copyright, and all of that's developed through your employees. You want to lock that down. As I said before, at-will employment, you can terminate at any time for any reason, with or without notice. Sometimes I have clients who like to have notice periods built in. So that'll be, feel free to resign with 30 days notice. That gives the employer a little bit of time to sort of wrap things up with that employee. I also put in oftentimes non-solicitation provisions. That can be non-solicitation of employees, certain consultants the employee had access to and worked with, and definitely clients and certain potential clients that the employee may have had access to. Always good to sort of protect yourself. So after the employment relationship ends for a certain period of time, that person is not able to solicit business or solicit that employee to leave the employee of the company or the association with the company. And sometimes I have clients asking for non-competition provision. So that's generally going to be your more senior employees. And depending on where that employee works and what choice of law you select in the employment agreement, you may have certain hoops you have to jump through. For example, in Maine, we actually have a statute. So you have to have certain language and notice periods for the non-competition provision to actually apply to that employee. Again, very important to work with an employment attorney on these to make sure that you're compliant with all laws, and so that you don't include a non-compliant provision and it's unenforceable at the end of the day. So that's your employment agreement. Very important to have, specifically for those restrictive covenants. When you then have a consultant, we've classified them properly. We want to memorialize the agreement. It's important to have a consulting agreement because you want to make it very clear the parties both agree that the consultant is properly classified as a consultant. They acknowledge they are responsible for paying taxes associated with the consulting fees. You also want to set forth the consulting fee. What is it? How often is it paid? How is it paid? What the services are? What are your expectations? And then also you want to have some representations in there. For example, with certain consultants, you want them to represent that they have adequate insurance. And finally, you also want to have termination provisions clearly defined. So if you're unhappy with the services, or they're not living up to your expectations, it's very clear when you can terminate that agreement. Interns, that intern agreements are going to look very much like an employment agreement, but the difference really is going to be some of those restrictive covenants I talked about really won't apply to an intern. They may not have adequate access to your information. You don't want to bind them up when that's not really appropriate. And I'm going to breeze through this because we're coming up on the end here. So the role of HR, why do you need to have HR? Do you need it? The answer is you really should have HR. As many of you may know, laws are evolving. In Portland, we now know that the minimum wage is going to be $19.25 effective January 1. You only know that if you have someone who is keeping abreast of these issues. The OSHA ETS, Emergency Temporary Standard, which requires employers with 100 or more employees to either have their employees vaccinated against COVID-19 or test. That actually just went back into effect after being stayed nationwide. So, you're a business owner, you're starting your business, you have a business that's operating. It's very hard to keep, yourself on top of these issues because they're constantly evolving. As an employment attorney, I am always reading the news. I am always keeping, myself informed of these issues because they change daily. So again, that's a really important reason why you want to have a trusted HR person in your office or an employment attorney who can help you navigate the changing waters of employment law. And that also goes for what laws apply to you. You'll see there on that slide that it depends on how many employees you have, what laws apply to you. So very important to have someone staying on top of those changes in your organization. Also, you're going to want that person to let you know what notices, posters you may need to have, and to help you craft your employee handbook. There are specific notices and posters you have to post. There are trainings that you have to do in Maine and in certain other states. An employee handbook's really great to have, critical to have everyone on the same page about policies, but also if there is, some sort of claim down the road, you have that employee handbook there to show that you had policies in place, complaint procedures, etc. So on the next page, you'll see we have a series of the policies that we recommend you have in place, and the posters. We have a link so you can see exactly in Maine what posters you must post. So teleworking, it's the new world we live in. It's great. It can also be problematic. You want to have make sure that you're tracking hours for non-exempt employees, have a clear policy, and be sure to follow it. Pros and cons we've listed there: less overhead, but you have less control over employees because you're not seeing them every day in person necessarily. It gives you access to a greater talent pool, but you're not there to supervise them as closely. Tax implications, if you have people working for extended periods in different states, maybe you're setting up a business there. That is a question to, of course, talk to your tax and employment attorney about. You have workers' compensation concerns because those laws apply in people's homes all of a sudden if you have them teleworking. And there's, of course, employee morale implications. So I will just say quickly that benefits, not my area, but we do have an amazing employee benefits group here at Eaton Peabody. And I will just say, as I mentioned before, that certain laws kick in if you have 50 or more employees, the ACA and COBRA, but having benefits is something that it's hard for startups to do at the beginning, but oftentimes it is a real retention and a tool to attract new talent because more and more employees are looking for benefits from their employers, even if you're a startup company. So again, we've got a great team here at Eaton Peabody, and happy to talk to anyone who's questioned about benefits. So I'm sorry, we are right up in the line here.
Katie, that was fantastic. This is Tommy again. Sorry, my camera was off. Thank you guys. That was a great, packed full of information presentation. I think this is going to be one that was super beneficial for those who were able to attend, but I think for those who may be able to watch this in perpetuity, on the recording. This will be actually some great legal advice. So thank you all. Just a quick reminder again that this presentation has been recorded. It will be available for replay on the Chamber's website and YouTube page. A copy of today's presentation, the deck, and any details or resources will also be included in a post-event email that you'll receive later this week. Another quick plug for all of our upcoming Chamber events. Be sure to check the Chamber website and calendar for any upcoming events. And you can also sign up for our weekly newsletter when you're there. Again, thank you to everyone for another great episode of Eaton Peabody's Growth Basics for Business, and to each of you for attending today and throughout the year. Another shout out to our sponsors, Eaton Peabody and Anania Bailey, for their commitment to this series. We look forward to seeing you at our next Growth Basics on Tuesday, January 11th. Have a wonderful day, enjoy the rest of the week, and have a safe and happy holiday season.